Good morning and welcome to the Relocation 101 Module 3. My name is Paula Hyman from the Ohio LTAP office, and I'm going to be your technical support again for today's webinar. Just a couple of housekeeping items, same as before. If you have questions, please put those into the questions pod, and we will answer your questions periodically throughout the presentation. There are two items available to download in the handout section now. So if for some reason you're unable to download those handouts, put your email in the questions pod and I'll email those to you directly. Thank you in advance for your participation with that. And I'm going to pass things off to Ms. Patty Moorman, Relocation Unit Manager with ODOT Central Office Real Estate. Patty?
Well, good morning, and it's good to have you guys back. And today we are going to be going over Module 3. Again, Module 3 is one of 7 modules. A couple of things I do want to point out is if you are taking the quiz, make sure that you don't walk away from the screen. If you are away for more than, I think, about 15 minutes, even though you finish the quiz, it does show it as incomplete. We are able to go in and look at the additional questions, but please try to, once you start the quiz, stay on the quiz so it doesn't keep popping up as incomplete. And after each module, you do receive you'll receive the handouts for the next module. The next one being on Thursday, which will be Module 4. And I do encourage you to, ask questions if you want to put the questions in the question pod. If you don't feel comfortable doing that during the webinar, but you do have questions, feel free. You can send me an email. You can give me a call. No question is too simple. Don't think it's please don't hesitate to ever ask a question. When I started out in relocation many years ago, I called with questions all the time to central office. No question is ever too easy. So please don't hesitate to ask any questions as we go through the module. So with that, we'll go ahead and get started. What we're going to talk about today is the eligibility for the replacement housing payments. We're going to talk about the different classes or the categories that the displacees can fall into, which will determine what they're eligible for. We're going to talk about decent, safe, and sanitary standards, and we're also going to talk about what makes a replacement house actually comparable. And keep in mind, what we're kind of just doing an overview, and in later modules we will get into a lot of this in more detail. So I think by now everyone is familiar with my name. I'm the Central Office Relocation Unit Manager, and your student manuals, they do have my contact information in case you do want to call or send me an email. So let's go ahead and get started. And the first thing we're going to do is we're going to talk about what our learning outcomes are going to be. So in this module, we're going to talk about, again, the eligibility requirements for the various replacement housing payments and who is eligible for what type. Now, on one of your handouts you have, it's called the Relocation Eligibility Matrix. And that's kind of your little cheat sheet that you can refer to both when you're out there as a relocation agent and also for any of these knowledge checks and for the quiz at the end. You'll want to hang on to this for later modules, and also if you do sign up, which hopefully you will, for the other relocation courses that get into more detail on replacement housing and residential. So we're also going to touch upon the persons who are not eligible for relocation housing payments. We're going to talk about the delivery of the relocation notice. And again, we're going to talk about decent, safe, and sanitary standards. I know when I started out in relocation, when it came to the replacement sites, it was at first it was hard to, it's just like, well, what makes it non-DS&S? What do I really need to look for? What is, what's going to make that house, that comparable house, something I can't use? So I've added additional stuff in here on decent, safe, and sanitary standards, just so you can get a better understanding of what you need to be looking for when you're actually out there looking at houses. We're also going to discuss the items of comparability as to what makes that replacement house, or when you're, or not only the replacement house, but when you're looking for your prime comp as well. What are you looking for? Okay, so the 4 classes of residential displaced persons. We're going to be going over each one of these today. Um, First, we're going to begin by discussing the types or the categories of the residential displaced persons as they are identified in the federal regulations and also in our PMP manual, which is online, and again also on that eligibility matrix handout that you have. And we're going to talk about how these classifications determine their eligibilities for specific replacement housing payments. And we're also going to discuss certain persons who are displaced but are not eligible for a replacement housing payment. So the big question with the someone on a highway project is, am I eligible for a replacement housing payment? But first, let's talk about the delivery of the relocation notice. I wanted to emphasize this again because you know, I want to make sure that I think this is something that is very important for a delivery of a relocation offer letter. In Ohio, only in very unusual circumstances and with prior approval from ODOT Central Office may the relocation offer be sent via certified mail with return receipt requested. So I just want to emphasize that again. I see this happening where the offers are being mailed out. So I just want to keep emphasizing that to you. If you're out there and you are making offers, make sure you're doing it in person unless you have really unusual circumstances. And if it has to be mailed out, it has to be by certified mail, and you do need approval to do that. Okay, so let's talk about a 90-day owner occupant. So as established in 49 CFR 24-401, a displaced person's classification, it depends on how long he or she has been occupying the property before the initiation of negotiations. So for this category, a 90-day owner occupant must have owned and occupied the property the agency is acquiring for at least 90 days before the initiation of negotiations. The 90-day owner occupant is eligible for a replacement housing price differential payment, and you'll see it. Yeah, there's this payment, you'll hear it named, several different ways. You may hear it be called an RHP. You may hear it be called a price differential payment, a replacement housing payment. It's all the same thing. So don't let the different names kind of confuse you. It can also be called a purchase additive or a supplement. So this is the amount that must be added to the acquisition costs of the displacement dwelling and the site to provide the comparable replacement dwelling for the owner. And how this payment is calculated, this is something that we will discuss in a later module when we get into more detail on replacement housing payments. So in addition to a housing payment, the 90-day owner occupant is eligible for a mortgage interest differential payment. Now, this is commonly called the increased interest costs. And they're also eligible for incidental expenses. Incidental expenses are more commonly called closing costs. So the interest differential payment, commonly called increased interest costs, that's when if they have a mortgage right now that's at 4%, and when they go to buy a new home, the prevailing interest rate is 6%, we're causing them to have an increased interest payment on a mortgage. How that's all computed and calculated is something we'll go into more detail again in the residential class, but one of the benefits or that they can get reimbursed for. So that's why I want you to understand what those payments are. Now, the total of these three payments cannot exceed $31,000. A housing payment, if it goes over $31,000, it's considered to be out of a normal, regular replacement housing payment. Anything that goes over $31,000, then you have to request, and it goes under the provisions of last resort housing. But within that 31,000, it's not just the housing payment, it's also if there's any increased interest payment, and it's also the closing costs. So you have to kind of keep that in mind and kind of estimate, if your housing payment is, you know, 27,000, you're probably going to go over the 31,000. So you're already probably going to be asking for last resort housing. So just remember, the 31,000, it's not just the housing payment, it's those three items all added together. Now, an owner can also choose to change their status. We're acquiring their house, they own the house, but for whatever reason, they decide when they go to their replacement house, they don't want to own, they want to rent. They can do that. And there's a process that we go through to determine a rent supplement payment or a down payment for that. I mean, they can become a tenant in the after situation. So how do we do that? Well, you have to determine what the market rent is on the home that they own, and then you go out and you comp them like they're a tenant, and you come up with a rent supplement payment. But you do all that after initially you start out, they're a homeowner, you calculate the RHP payment. Then they tell you, okay, my RHP payment is, 13,000. That's fine, but I want to rent. So then you turn around and do a second payment as if they are a tenant. Now, the amount of this rental assistance payment, if they choose to do this, for a 90-day homeowner, it cannot exceed the amount they would have received as a replacement housing payment. So again, if their replacement housing payment that you established was $13,000, when you go out and comp them as a tenant, the most they can get is the $13,000. They cannot profit or get a higher amount because they chose to change their status. Okay, we are ready for our first knowledge check. And we're going to do these a little different this time. These knowledge checks are they're kind of as like a story problem or a case study. I'm going to put up on the PowerPoint the case study, and then we're going to have the question for the knowledge check. So here's the first situation. So we have the Hunter sisters inherited their dwelling and moved in 2 years ago. A state and federally funded highway project requires the acquisition of their home. So which payments may they be eligible to receive? So are they eligible for A, the price differential and incidentals, B, a mortgage interest differential, C, rental assistance, or D, all of the above? And you can use your eligibility matrix chart. You should be able to come up with the answer. Great. You guys all got it right, 100%. That's correct. They are more than 90 days. They are owners, so they qualify for also a housing payment, the increased interest if they have it, closing costs, and if they want to change their status, they can also qualify for rental assistance. Okay, so let's go to the next one. So the Maitlands purchased their home and moved in 5 years ago. The city, via an ODOT program LPA project, is rerouting the highway in their neighborhood, and they must acquire the Maitlands home. So what is the eligibility for the Maitlands? Price differential and incidentals, mortgage interest differential, rental assistance, or all of the above? %, all of the above, and that is the correct answer. They have met the 90-day owner occupancy status, so they're eligible for the RHP, the increased interest, the closing costs, and if they want to change your status, they could qualify for a rental assistance payment. Okay, let's go to the next one. So ODOT is acquiring Jake Gilmore's home for a highway project. So Jake purchased a home 10 years ago, and he moved in 2 months ago when his tenant moved out. So what is Jake's eligibility? This one's a little trickier. Is he eligible for the price differential and incidentals, the mortgage interest differential, none of the above, or A and B? Okay, so the answer is none of the above. And this is why. Jake has not occupied that house for 90 days. He's been in it, even though he has owned that house for 10 years, he has occupied the home for less than 90 days. So he does not qualify for a replacement housing payment. He does not qualify for the mortgage interest or the closing costs. However, he may qualify for a rent supplement payment and a down payment under the provisions of last resort housing, being a less than 90-day owner occupant. And that's something we're going to discuss next. Remember, you have to occupy for 90 days or more prior to the initiation of negotiations to qualify for that replacement housing payment. And along with the replacement housing payment is the closing costs, which are the incidentals, and the mortgage interest differential, which is the increased interest payment. Okay, so now let's talk about a 90-day tenant. So these are people who have rented and occupied the displacement dwelling for at least 90 days, immediately prior to the initiation of negotiations. The displacees within this category may be eligible for either a rental assistance payment or a down payment assistance. So the rental assistance payment may not exceed $7,200, and it is used to assist in the rental of a replacement dwelling. So, and 7,200, this payment, if it goes over 7,200, then it falls under the provision of last resort housing. So just remember, rental assistance 7,200 is the number that it should not go over. Now, the down payment assistance also cannot exceed the 7,200. Again, unless you're under the provisions of last resort housing, which we will talk about at a later time. So what's interesting about this down payment assistance, this is a really good opportunity for a tenant. It's sometimes it's the only option and the opportunity they have to become an owner. So they can take their rental assistance money and they can use it as a down payment to buy a house, assuming, credit is good and they're able to do that. But one thing about this rental assistance payment, if the rental assistance payment, let's say you calculate that at $3,500, the minimum down payment is $7,200. So they can take that rental assistance payment of $3,500, turn it into $7,200 as a down payment. So, I mean, it's a really good opportunity for, some of these, families, single moms, great opportunity for them to turn a rental assistance payment into more money and use as a down payment. Now, the payment is the difference between the monthly rent plus utilities necessary to rent a comparable replacement dwelling as determined by the agency. Again, you're checking the market, and you come up with your prime comp and your other comparables for your determination. It's the difference of it's that base, and you compare it to the base monthly rent of the displaced dwelling. So you're going to look at where are they at, what are they paying, plus utilities, and then what is it going to cost them to go out and rent and pay utilities at a replacement site. And once again, 7,200 is set as the maximum. However, it can be exceeded through the provisions of last resort housing. And again, that's something we will cover at a later time. Okay, we have our second knowledge check. And again, these are in the form of kind of like case studies, scenarios, and I'll read those and then you will mark your answer and then we'll go over them. So here's the first one. Stephanie Kastner and her roommate rent a large house. They have been in occupancy for 2 years and each pays one half of the rent. ODOT will purchase the building. So what is Stephanie and her roommate eligible to receive? So is it A, a rent supplement payment, B, down payment assistance, C, A and B, or D, A and B only if it's in last resort housing? Okay, we got a few answers, different answers, but the majority of you did get the correct one, which is A and B. So they're eligible for the rent supplement payment and or the down payment because they have been in occupancy for more than 90 days. They do not, it doesn't need to go into last resort housing unless the market, unless the amount would go over the 7,200. But one thing you would need to make sure, that they are one household, and they don't pay rent separately. For this, we're going to, they say each pays one half of the rent. So you got to make sure they are not. Um, you got to make sure that they are not, that they are one household.
Patty, I had to reset your presenter status. People couldn't see your slides. So please reshare your screen.
Oh, okay.
Perfect. Thank you.
Okay. Okay. All right. So we're ready for the next question, next scenario. Okay. Raymond Raymond Lorello and his family have rented a 3-bedroom duplex since June 1st. The city of Steubenville is acquiring the duplex as part of a federally funded light rail facility, makes an offer to acquire the property from the owner landlord on October 1st. So what is the eligibility of the Lorellos? Okay. Sorry, I got a bit of a cough. um, okay, so the options are a rent supplement payment, down payment assistance. Okay. Um, okay, so the correct answer is A and B. Again, the Raymond and his family are 90-day tenants, and they may be eligible for the rent supplement payment or the down payment assistance because they have met the 90-day occupancy requirements. Okay, let's move on to Paula, are we having problems with my screen showing again?
Yes, in between, for some reason, it's not coming back up, so I'm going to have to just reset you.
Okay. Okay, are we ready to move forward, Paula?
Yes, we are. In your audience view, you'll see that we are looking at the correct screen.
Okay. All right. Okay, the next scenario is about the Sheets family. So in January, apartment 222 was vacant. Negotiations for the property acquisition began with the owner of the apartment building on February 12th. And the owners informed ODOT that the Sheets family moved in on February 1st. So, what is the eligibility for the Sheets family? Is it rent supplement payment, down payment assistance, A and B, or A and B only if in last resort housing? Okay, and most of you did get the correct answer. The Sheets family does not meet the length of occupancy requirements for a 90-day tenant. So they would not be eligible for the rent supplement payment or the down payment under normal circumstances. However, they may be eligible for the rental assistance or down payment under the provisions of last resort housing. Okay, so now let's talk about owner occupants who do not meet the 90-day occupancy requirement. So, less than 90-day occupants, whether it's tenants or owners, are those occupants who move in less than 90 days prior to the initiation of negotiations or after the offer is made. So we have already discussed the length of occupancy requirements outlined in the federal regulations, but these regulations also state that an agency must still provide assistance to someone when comparable replacement housing is not available within the displaced person's financial means, even when they do not meet the occupancy requirements. Provisions for this type of occupant are contained in 49 CFR Part 24,404 and in Section 6607 of our relocation manual. So we will discuss the term financial means a little later in this module, but basically the less than 90-day occupant, who will almost always be a tenant, will be eligible for a rental assistance payment or a down payment in the same manner as a 90-day occupant, but it is paid under last resort housing. Those provisions allow us to still make them eligible for a payment, last resort housing. So just remember, less than 90 days, last resort housing, they can still be eligible. Okay, we're ready for knowledge check 3. And Paula, let me know if we have problems with the screen again. Okay, first one, Dinah Eaton moved into the dwelling 1 week after the initiation of negotiations. She was desperate for a place to live, and the landlord told her that she would not be able to stay long term since the landlord intended to sign with ODOT shortly. So, what is the eligibility for Dinah Eaton? A rent supplement payment, a down payment assistance, replacement housing payment, or A and B only if in last resort housing? Excellent. You guys all got it. Under the provisions of last resort housing, provided she remains in occupancy until ODOT relocates her or acquires the property. Because she has not met the 90-day threshold. She's less than 90 days. Next question. John Barker, a long-term owner-occupant, is negotiating with the city of Gahanna, which needs to acquire his home as part of a roadway relocation project. The home is occupied by John and his son Jared. A week before closing, John suddenly dies and Jared inherits the home. The will be probated in 1 week, and Jared is now the sole owner of the property. He closes with the city 1 week later on the same terms and conditions his father previously accepted. So, what do you think Jared's eligibility is? This is a little tricky. Rent supplement payment, down payment assistance, replacement housing payment, A and B only if in last resort housing. Oh, so we're kind of split on this one. The correct answer is A and B, but only in last resort housing. Jared is now the owner, but he does not meet the 90-day requirement for an owner occupant because he was not the previous owner. He's now the new owner. This payment may not exceed, so he is entitled to either a rental assistance or a down payment. And this payment may not exceed what Jared would have been eligible for if he were a 90-day occupant. So because he was not the owner at the time of the offer, he is a less than 90-day occupant. Okay, next scenario. Kevin O'Grady is a Canadian citizen who resides in the United States for employment reasons. He readily acknowledges that he is not legally present in the United States and is not legally employed here in the U.S. His dwelling is being acquired for a federally funded project. Kevin occupied his dwelling 4 months prior to the initiation of negotiations. So, what do you think Kevin O'Grady's eligibility is? a rent supplement payment, a down payment assistance, replacement housing payment, or none of the above. And most of you got the right answer. It is none of the above. Kevin is not generally eligible for any relocation assistance or payments since he acknowledges that he is not legally present in the United States. This and other situations like it will be explained in discussions in the next slide. So now we're going to talk about the persons ineligible for relocation housing payments. First one, aliens not lawfully present in the U.S. So not everyone who occupies a residential property will be eligible for a replacement housing payment. However, the regulations provide for assistance in cases of exceptional or extremely unusual hardship. And this is discussed in section 6110 of our relocation manual. If there's a lawful dependent, a spouse, or a person, sometimes exceptions can be made if it's a hardship situation. So when we talked about the different categories of residential displaced person, each one's eligibility was tied to the occupancy of the displaced dwelling. So seasonal residents are those people who are not occupying the subject property as their dwelling. In the federal regulations, dwelling is defined as the place of permanent or customary and usual residence of a person. For example, a couple may have their principal residence in Marion and have their winter residence in Florida. If their Florida residence is acquired for a federally funded project, they would not be eligible for a replacement housing payment, although they would be eligible for advisory services and moving expenses. So how would you determine someone's principal residence? Well, you could ask for a copy of the federal or state income tax, voter's registration, driver's license, vehicle registration, possible homestead registration in the Ohio County, or even an affidavit. Now, you're really going to only ask for this stuff if you think there may be a possibility or you have a question that they're seasonal residents. You're not going to ask for this information every time. So we've said previously that a person's eligibility is established on the date of the initiation of negotiations. So if someone moves before negotiation begins, he or she would not be eligible for the replacement housing payment. Agencies and relocation agents should always advise persons during the interview process. Remember back pre-ac interview, the important questions you got to make sure you ask. You at that time, you also need to make sure that you advise them not to move prior to this date, since it will affect their eligibility in relocation assistance. You especially need to make sure you emphasize this with tenants. I've seen tenants, even though you tell them if they move early, they just lost a rent supplement payment, possible down payment on a house. So after the agency acquires a property, the agency may lease it for a time to new tenants if it is not immediately needed for the project. So these new residential tenants who moved into the property after the agency's acquisition would not be eligible for a rental assistance payment or a down payment assistance. Normally, if we've acquired the property and we're going to let someone move in afterwards and pay rent, that's under a property management lease. It's not part of a relocation parcel. So unlawful occupants would be those persons who are occupying the subject property but may have no right to be there. For example, an unlawful occupant could be a person may be living in a tent or an abandoned house on a property without the owner's knowledge or consent, and the owner is not receiving any payment. This unlawful occupant is not eligible for replacement housing payment. However, we have a lot of howevers in relocation. The federal regulations do provide discretion to the agency to consider the person to be in lawful occupancy and make him eligible for relocation assistance and payments, depending on the situation. So remember, but just remember though, that's an exception to the rule. And remember, regardless of the occupant's status, every owner is always entitled to be paid the fair market value to acquire their property, even if they didn't meet the occupancy requirements for a housing payment. They still always are entitled to the fair market value to purchase their property. Okay, so we are now on Knowledge Check 3.4. We have a lot of them today. So again, these are scenarios for you to read and to tell me what the eligibility is. First one is the Nussbaums have moved a modular home to a lakefront lot in Apple Valley Development, and they occupy it on the weekends. The lakefront lot will be acquired for a federally funded project. So what is the eligibility of the Nussbaums? A replacement housing payment, a rent supplement payment, down payment assistance, or none of the above? Excellent. You guys all got it right. None of the above. And the reason why, this is their primary residence, vacation, even seasonal. So they do not qualify. They're not eligible for a housing payment at all. Okay, next question. The city of Fremont needs to acquire Harvey Norton's house for a highway improvement project. After acquisition, Harvey leases the house back from the city for 6 months at a fair market rent of $900 a month, which is higher than the mortgage payment he was making on the house for the past 20 years. Harvey was the original owner occupant and then became a holdover tenant. So, what is Harvey eligible for? Is he eligible for a rent supplement payment, down payment assistance, A and B, or replacement housing payment? Oh, okay. The correct answer is replacement housing payment. So Harvey may be eligible for a replacement housing payment, the mortgage interest differential, and the incidental expenses, since he owned and occupied the acquired property for more than 90 days prior to the initiation of negotiations. Now, had Harvey moved into the property as a tenant only after the city's acquisition, he would not be eligible for any relocation benefits. And maybe an easier way to look at this is, you have a highway project. You've got a family in this house. They sell the property to ODOT, but they're asking to, since the clearance date is way out there, can we just go ahead and stay in here for another 6 months or 12 months? And in doing that, they do become a over tenant. The district says, yeah, we can allow you to stay in there for another year. No problem. We're not gonna, the clear date's 2 years out. The fact that they stayed on and became tenants does not take away their eligibility for that housing payment that they had at the initiation of negotiations. So maybe that's a kind of an easier way to understand it. It would be different than ODOT acquiring the property. Somebody new jumps in and they're under property management as a new tenant. Okay, next question. What are the Donleys eligible for? The Donleys move from rental property 2 weeks ahead of ODOT's offer to purchase from the fee owner. They contact ODOT and inquire about the relocation assistance benefits. So what are the Donleys eligible for? Are they eligible for a rent supplement payment, down payment assistance, replacement housing payment, or none of the above? Excellent. This one was a pretty easy one. They moved. They moved before we made the offer. Hopefully, during that pre-acquisition interview, clearly says, I told them not to move. I told them not to move. If they moved, it was going to jeopardize their benefits. As you will recall in module 2, we talked about the importance of that pre-acquisition interview. You want to make sure it's documented that you made them aware they shouldn't move. And tenants are the ones that, wait, I will see this happen. Okay, let's talk about common elements of replacement housing payments. So, regardless of the category of the displaced person, whether it's 90 days, less than 90 days, and the type of the replacement housing payment, there are common elements of all the payments. So, replacement housing payments, also called RHPs, may be made only to occupants of the dwelling from which displacement occurs. So as mentioned, when we discuss seasonal residents, this means that the dwelling is their usual and customary place of residence. So RHPs may be made only if the housing to which the displaced person moves meets certain standards. So these standards concern the size and the physical condition of the replacement dwelling and its utility and affordability for the displaced person. We will get into the decent, safe, and sanitary here shortly. Go into more detail as to what makes a home non-DS&S. The agency may pay the replacement housing payments only if the displaced person purchases or rents and occupies the dwelling within 1 year. So, it's got to meet, it's got to meet the size, physical condition, utility, and they got to be able to afford it. It has to be decent, safe, and sanitary. And they also have to occupy it within 1 year. So for a displaced homeowner, the year begins on the latter of. So if they are an owner, If the owner settles with the agency, this would be the date of closing. That's when their 1 year starts for them to own and occupy. In the case of a condemnation, if it's filed for appropriation, this would be the date that the final amount is deposited in court. They reach a settlement, the final amount is in there. Then they have a year because now they have been given the money. It is available for them to purchase. Now, in Ohio, we offer a comparable dwelling before the acquisition of the property is complete. So the clock starts ticking from the date the owner receives the payment. Now, a displaced tenant must rent or purchase and occupy a DS&S replacement dwelling within 1 year of the date he or she moves from the displacement dwelling. Their 1 year clock starts ticking when they move. The 1 year limitation can be waived by the agency for good cause. So, what would be a good cause? Could be that the owner is building a new home. It's just not quite ready yet. They need another couple months. The agency, they're getting close to that 12 months. The agency gives them an extension, maybe for another 2, maybe for another 3. Yeah, the approval of that extension, of course, they're going to look at, their project, their clear date, and how's that going to work. So for owners, claims for these payments, for replacement housing payments, must be filed with the agency 18 months after the latter of either the date of displacement or the date of the final payment. They 1 year to occupy, but they still have, even after that, they still have time after that to file a claim. Now, usually if it's a residential parcel, they're filing the claims, uh, they're not waiting 18 months to get reimbursed. If you have a business, sometimes it can go out to the 18 months. So just remember the time limit to actually file a claim is 18 months. For tenants, the claims must be filed within 18 months of the day of displacement. So for tenants, 18 months from the day they move. For the owner, is 18 months from their when they receive their money. So the agency, again, may waive the 18 months for good cause. So RHPs are intended to assist the displaced persons in obtaining comparable replacement housing and to compensate for the increased housing related costs imposed on them by federal or federally assisted projects. Thus, the final payment computed is based on the cost of either a comparable replacement dwelling or the replacement dwelling actually occupied, whichever is less. An agency cannot ask a displaced person to waive his or her rights to a relocation assistance, including an entitlement to a replacement housing payment. So why is this important to know? Because even though our Attorney General's office may want to create some sort of global settlement, you can never ask a displacee to waive the relocation benefits. Those are separate. They're not part of a settlement. Okay, so this is a lot of information. Is there any questions before we move on? Okay, seeing none, we'll continue on. Okay, so now I want to get into decent, safe, and sanitary. And, this is where not only when you're looking, um, you're inspecting the home that ODOT is acquiring, and you have to uh, make a statement in your notes that it's decent, safe, and sanitary or non DS&S. Um, but even more important, when you're looking at um, comps, you're looking at comparable properties, and you're looking at the displacement property. This is the home, the dwelling, decent, safe, and sanitary. This is going to be important. So, a basic requirement of the relocation program is that the replacement housing made available to the displaced person must meet certain standards. So these standards are contained in the interrelated concepts of decent, safe, and sanitary housing and comparable replacement housing. So first, we're going to discuss the decent, safe, and sanitary standards. And you'll more often hear it referred to as DS&S. So the term decent, safe, and sanitary refers to the physical condition of a replacement dwelling and its effect on the health and safety of the occupants. So basically, a dwelling that meets the requirements of a typically local housing and or occupancy code will be decent, safe, and sanitary. But it is important to understand the distinction between housing and occupancy codes and building codes. So building codes set standards for construction, and they apply only to new construction and certain additions and alterations. Housing and occupancy codes set standards for the habitable, and they apply to all dwellings in a community. So if an occupancy code changes to require smoke detectors, for example, all dwellings would be required to have them. Housing and occupancy codes are narrower in scope than building codes. They are concerned with only those elements that influence health and safety. Building codes are concerned with conformance to current building standards. So most local housing and occupancy codes are adaptations of one of the national model codes established by code setting organizations. So what do we look for when performing a DS&S inspection? And at ODOT, there is a form for a DS&S inspection. We'll go over that form more when we get into the other course that details residential, but I just want you to know at this point there is a special form. There is a checklist that you will go down when you're doing an inspection. So in addition to being structurally sound, the replacement dwelling, it must be weather tight and in good repair. For example, the roof must be in good condition, not leaking, and there can be no missing or cracked windows. And for a replacement home, the one that the property owner actually chooses to purchase, it will amaze you the condition of some of these houses that they do want to purchase. So you got to look for this stuff. I've been in houses where you could stand in the kitchen and look up and see the sky. Or you walk in the bathroom and the floor is so spongy, you don't want to stand in there. So you do have to look for these in that replacement site that they want to buy. The unit must have an adequate and safe electrical system for lighting and other electrical services. There should be no exposed wires, open switch plates, or outlets. The heating system must be able to sustain a temperature of approximately 70 degrees. Note that there is no requirement for air conditioning, even though this might be a hardship in some, southern states. Air conditioning is not a requirement. The replacement dwelling must be adequate in size for the displaced persons or family. Now, this is something that you may come across, occasionally. The adequate in size refers to the number of rooms, bedrooms, living space needed to accommodate the displaced person or the displaced family. The number of bedrooms normally will be given the first consideration. The number of persons occupying the bedrooms cannot exceed what is permitted by the local housing codes or by the policies of the agency if there are no local codes. So normally, a decision concerning adequacy would involve the correlation of the age and gender of the adults and children sharing the dwelling and the appropriateness of sharing bedroom space. So if no local codes, the following shall apply unless the agencies sponsoring the project waive them. And you can find this in ODOT's Relocation Manual section 6115. Children of the opposite sex under the age of 10 may occupy and share the same bedroom. One child under the age of 2 may occupy the parent's bedroom. Except for the above situation in married couples or cohabitating couples, persons of the opposite sex should not be required to occupy the same bedroom. So the bathroom must be well lighted, ventilated according to privacy to the user. And in some locales, the bathroom must have a vent fan or a window, or it is not considered to be properly vented. So you kind of got to know what is required by the local. There must be a sink, a bathtub, or shower. There must be a toilet, all in good working order, properly connected to water source and sewage drainage system. We have a project down in southern Ohio in a mobile home park right now where the runoff from the bathroom just goes right under the mobile homes. I've seen that before. Obviously, non-DS&S situation. There must be a kitchen area in all dwellings except a sleeping room. The kitchen area must have a sink, which is connected to potable, drinkable, hot and cold water, and it also must have a proper sewage drainage system. There must also be adequate space, utility connections for a stove and a refrigerator. There must be an unobstructed method for the displaced person to exit the dwelling and reach safe open space at ground level. And this is probably a situation you'll run into the most of needing to have a solution. Barrier-free means the dwelling is free of any barriers that would preclude reasonable entrance, exit, or use of the dwelling by a disabled person. In addition to a ramp that you see in the slide, what other modifications do you think may be needed to make a dwelling barrier-free? For someone in a wheelchair, it could be widened doorways, lowered counters, bathroom modifications. For hearing impaired, it could be a doorbell that actually actuates lights. For visually impaired, perhaps looking for a floor plan that is similar to the displacement site. Now, as I mentioned before, we have a form for a DS&S inspection, and even though we'll go over it in more detail at a later time, I just wanted to throw it up here so you could kind of see what it looks like. You're going to fill in information on the particular structure at the top, and then you have a checklist. And this helps you to, as the things that we have just gone over, you're just going to go down, and hopefully you are going to say yes in all of those categories. One important thing when you're doing this inspection is you make sure that the displaced person understands you are not a licensed home inspector. This inspection in this form is only for the agency's purposes. So, comparable replacement housing. Next, we're going to talk about comparability. No person may be required to move from a dwelling unless they have been offered a comparable replacement dwelling. Now, we already know it has to be DS&S, but now let's talk about what's going to make it comparable. So the displacing agency must offer each displaced person at least one comparable dwelling, absolute minimum, and whenever possible, a total of 3. And later again, in in the more advanced course for residential, we will talk more about what the requirements are to get approval for using less than 3 comps. So this is a crucial part of the displacement process, since the comparable replacement dwelling will form the basis of the computation for the replacement housing payment. So many elements of a comparable replacement house, they deal with the specific needs of the displaced person, such as financial means, reasonable access to employment, access to public and commercial facilities. This just reemphasizes the critical importance of what was stressed previously about advisory services, the need for the agency to determine the displaced person's needs and circumstances. And this can be accomplished only by personal contact with each displaced household early in the process. Again, the importance of that interview, that sit down interview that you do with that family during the pre-acquisition interview. That information is what's going to help you to know what are their needs when you're out there looking for comparable housing. A guiding principle in comparability is the concept equal to or better than. And that is a phrase that you will see over and over again at ODOT. So in addition to being DS&S, comparable properties must be functionally equivalent. The term functionally equivalent means that it performs the same function and provides the same utility. The replacement dwelling should be generally similar to the displacement dwelling with regard to the number of rooms and areas and the living space. Now, this doesn't mean that the replacement dwelling must meet a tape measure comparison to the acquired property. The comparable also does not have to be identical to the displacement property. You're probably not going to be able to find something that's identical. Reasonable trade-offs are acceptable when the replacement property is equal to or better than the displacement dwelling. Just remember, it needs to be equal to or better, can't be less. The relocation program's emphasis is on function. The replacement dwelling, when compared to the acquired dwelling, should perform the same function, provide the same utility, possess the same or like amenities. So this requires that the principal features of that acquired dwelling be present in a comparable. The comparable should have available space for comparable purposes as used in the acquired dwelling. Remember, there can be trade-offs. For example, if the displaced dwelling contains a pantry and a comparable does not have a pantry, ample kitchen cabinets could be a substitute for a pantry. An insulated and heated space in a garage may prove adequate replacement for a basement workshop. So physical inspection and verification with listing agents on recent improvements to the interior as well as the exterior of selected comparables will clarify whether possible replacement dwellings meet standards of comparability. Personal inspections must be made on all comparables for ODOT. This is a subjective process, and special care should be taken to ensure that the comparables are truly viable replacement options that meet that definition. If you're not inside looking at this house, looking for those DS&S items that need to be on that checklist, how do you know that this replacement house is comparable? So it is important to note that the agency is selecting comparables to establish the maximum replacement housing payment and to prove there is a comparable replacement housing available at the time of the displacement. Most displaced persons will select replacement housing other than comparables used for calculation of benefits. Now, if you talk to a lot of people in relocation, they'll say that an owner never purchases one of your comparables. Well, I have had I have had more than one actually purchase a comparable. So make sure when you're choosing your comparables, whether it's the prime comparable or the other two that go with it, make sure that they are homes that really do meet all of the criteria, and they're homes that you yourself would want to move into. So in general, adequate in size, this relates to the occupancy standards in the local housing and occupancy code. However, it is important to take into consideration the particular composition of the displaced household. For example, a family with a teenage son and a daughter would require one more bedroom than one with two teenage children of the same sex. Similarly, special health related needs of a household member could affect the needed size of the replacement dwelling. Unreasonable adverse environmental conditions may have a serious negative effect on the habitability of a replacement dwelling. Proximity to environmental influences such as a sewage plants, factories dispensing smoke and other pollutants, salvage yards, dump sites, similar unhealthful and unsafe conditions that may make a dwelling unsuitable as a comparable. So when you're choosing what you're going to use as a comparable, make sure you're looking to see what's the environment, where is this house sitting, what's around it, whether a particular factor or a set of factors has a sufficiently negative impact. It's a matter of judgment for you, the relocation agent. But you look at the picture. Would you want to live in an apartment that had that kind of a factory in your backyard? So the adequacy of access to commercial and public facilities is also a case-by-case judgment call. It is important to determine for each displaced person the institutions or the facilities upon which there is a strong dependency. Again, that goes back to the interview, talking to the family, talking about their needs. Do they want to stay in close proximity to their church, to shopping, to jobs? A family with children would be concerned with the school system. An elderly retired couple without a car would consider it important to be near a grocery store or even to be close to the hospital or a doctor's office. Now, this does not mean that the agency must comply with the displaced person's every desire, especially to particular schools or to shopping areas, but rather the agency should make a sincere attempt to accommodate the displaced person's preferences. And if they have, especially high school age children, they're probably going to be very particular or specific about staying in the school district that they are currently in. So the agency must consider both needs and availability. Continued access to the displaced person's place of employment is also a very important consideration. The objective, excuse me, the objective is that such housing be reasonably accessible to the person's place of employment. You need to look at where do they work, what is the current distance, and you definitely need to keep that into consideration when you are looking for comparable houses. Now, referables need not be limited to housing equally distant from employment as the displaced dwelling, but time and distance from the referral should not endanger continued employment. And there are certain types of employment that do require you to live in a certain township or a certain county or a certain city. So those are things you need to be, you need to know, to so that hopefully the comparables you find can can meet can meet those needs. Typical size would be considered in terms of square footage, and the replacement site should contain normal site improvements, including customary landscaping. The replacement site need not include special improvements such as outbuildings, swimming pools, greenhouses, or excessive acreage, also referred to as major exterior attributes. The distinction is important for computing certain replacement housing payments for 90-day homeowners. In some instances, the federal regulations require a carve out and the resulting typical home site computation. Now, this is something that we will be discussing in the next module. So just touching on it in this one. So I just want you to understand that there could be situations where you are creating a typical home site computation to help you and assist you in finding a comparable replacement housing payment, something that is normal for the area as far as outbuildings and amenities. The displacing agency may only refer to displaced persons um, to housing that has recently been confirmed as being available. Similarly, in making payment determinations, only current available listings may be used. And prior to the offer, on the day of the offer, you must call and you must verify that the comparables you are using, that you use to compute their offer, that they are still available, that owner, if they wanted to, they could walk in that afternoon and put an offer on that home. If that home is now under contract, it's not available. A sales or rental dwelling that is no longer on the market, it may not be used to determine the sales or rental price of a comparable also. So within financial means, the concept of financial affordability is defined differently for displaced homeowners than for tenants in the regulations. The financial means test for a 90-day owner-occupant is that the cost of the comparable replacement dwelling does not exceed the total amount of the acquisition price for the displaced dwelling plus the replacement housing payment. For a 90-day tenant occupant or a less than 90-day occupant, the financial means test is that the monthly rent plus the utilities for the comparable replacement dwelling does not exceed the base monthly rental determination for the displaced dwelling plus the amount of the rental assistance payment. If the replacement housing payment is not available within the financial means of a displaced person, the replacement housing of last resort may be necessary in order to complete the relocation. The last comparability standard affects persons who are receiving government assistance. In their case, the replacement dwelling may have to meet size requirements indicated by a particular program rather than the ones we have discussed. This is typically determined by bedroom count for HUD, for a HUD housing voucher program. You know, if you have a tenant that is currently in a voucher program, which is also known as Section 8, you know, you will have to check with HUD to find out what their requirements are for bedroom count for that family. In summary, a great deal of judgment is required in applying the minimum standards for comparable replacement housing. The criteria sometimes become subjective in application, and an attitude of reasonableness must prevail. In implementing comparability and the DS&S standards for replacement housing, it is important to remember that the overall objective of the program is fairness and equity to the displaced persons, equal to or better. That is your goal in finding the comparable replacement homes, is you want it to be equal to or better. If what they're in is non-DS&S, obviously it's going to be better. But we need to put them in a replacement home, a comparable replacement home that is available for them to walk in and put an offer on. We need to be giving them the funds to be able to do that, and it needs to be equal to or better than the home that they are currently in. Okay, so we're now to the point of just reviewing our learning outcomes. So what types of payments would our 4 classes of displaced persons be eligible for? So we have a 90-day owner occupant. A 90-day owner occupant could receive a price differential, which would be an RHP, a mortgage interest differential, which would be increased interest, incidental expenses, which are closing costs, or a rental assistance if they choose to change their status. A 90-day tenant occupant could receive a rental assistance payment, or they could flip it over and turn it into a down payment. A less than 90-day occupant can receive a rental assistance payment or a down payment. Persons ineligible for replacement housing payments, if they're ineligible, they're not eligible for any benefits. So some of the things that for decent, safe, and sanitary standards that you need to look for, you need to make sure it's structurally sound, safe electrical, adequate heating, adequate in size, safe and unobstructed egress, barrier-free for persons with disabilities, separate bathroom with shower and tub, or tub, kitchen area with sink, and stove, and refrigerator hookups. And remember, you don't want to stand in the kitchen and you don't want to be able to see the sky. And you don't want to walk in the bathroom and have the floor feel so spongy that you immediately back out. So, how do you access comparable replacement housing? You access the comparable replacement housing by answering the questions about which comparable should be selected as you analyze the differences between the displacement site and the replacement dwellings. And hopefully, you have a better understanding of the difficulties that can often be encountered when locating the comparable housing. So, this is going to conclude Module 3. Do we have any questions before we end this module and you are then sent the link or can access to take your quiz? Any questions? Okay. Seeing no questions, if you have any pop up later, please feel free, send me an email, give me a call. Please try to get your quiz done today if you can, or at least by tomorrow. And otherwise, I will see you guys all, or I will talk to you guys all on Thursday for Module 4. And thank you all for attending today.